Welcome everyone once again to this topic, to this course, Criminal Law, course code PUL341. Remember the last time we talked on it, we said it's a very interesting course and that is also very detailed and involves every one of us. Today we are going to look at generally what is criminal law. Not everyone agrees on what kind of behavior should be permitted or on which personal choices should be encouraged or discouraged. There are many rules that govern human conduct and still more standards by which it can be judged. Some of these rules carry the force of law, and law has been defined as that which is laid down, ordained, or established, a body of rules or action or conduct prescribed by controlling authority and having binding legal force. It is only human conduct which violates the law that properly can be called criminal law. Other forms of behavior may be undesirable or even reprehensible. They are not crimes. E.g., or for example, begging in the public. In many societies, if not all, it is many people do not accept it or it's unacceptable. Some even reprehend it, but it is not seen as crime. Why? Because there are no laws against such, and of course, they have no punishment prescribed for it. These are things that are natural, even though they may be unacceptable by some people, but that doesn't make them crime. We're going to the next slide now to look at what crime, therefore, is. Yes, our next slide takes us to what then is crime. A precise definition of crime will be difficult, as there are many definitions and there are publications on the subject. However, we shall look at some definitions and see what is common to them. According to Karibi White, a one-time Supreme Court of Nigeria, crime is any antisocial behavior which falls within the general disapproval of the community. Mere general disapproval, however, has never been sufficient. The disapproval must be supported by punitive sanctions. Also in Articles Trade Association and Attorney General for Canada, Lord Atkins remarked that the domain of criminal jurisprudence can only be ascertained by examining what acts at any particular period are declared by the state as crimes, and the only common nature they will be found to possess is that they are prohibited by the state and that those who commit them are punished. From these two definitions, we can see that certain things are common in them. One of them is that there must be disapproval by the community, but by the society in which such offenses or crimes are being committed. Also, there must be punitive sanctions prescribed by any law for them to come under the definition of crime. We shall now go into the next slide to see more definitions and also make up our own definition of what we think is crime. The problem of definition is even more glaring, as not even the statute, the criminal code, the penal code, or other statutes that we use for this course even prefer a definition for crime. However, Section 2 of the Criminal Code defined crime as an act or omission which renders the person doing the act or omission liable to punishment under the code or under any act or law. The common denominator here is that whatever acts or omission that is prohibited must be backed up by sanction. The disapproved behavior must be punished. This is the main distinguishing factor, as the societal connotation of crime plays a major role in determining what the legislators may prohibit as crime. The essential characteristic of crime is that it is behavior which is prohibited by the state as an injury to the state and against which the state may react, at least as the last resort. We shall go on to the next slide to continue on the definition of crime. From the above definitions, one can deduce a crime to be any act or omission prescribed by the state with punishment for its violation. Again, an understanding of what law is, criminal law can be understood then as that body of rules and regulation that defines and specifies punishment for offenses of a public nature or for wrongs committed against the state or society. Criminal law is any conduct that threatens the happiness or security of its members. It is part of the substantive law that creates and defines fundamental rights and duties. It includes other forms of law found in the penal codes of the various states that specify rules which must be followed in sound life. In other words, from all we have said so far, we can see now that definitions of crime, no matter where you are coming from, no matter the duration you find yourself, however you define crime, it must be something consisting of conduct, consisting of acts or omissions which are not acceptable by the society. It doesn't stop there. It must be prescribed by the states. In other words, the legislation must put down laws against such acts or omission. Again, it goes further to say that such acts or omission must be something against public, it must be a public wrong. In other words, it must not be affecting just you, but also the society at large. And because it's affecting the society at large, there must be punishment, there must be some form of deterrence, there must be some form of reformation for, for its violation. So punishment must be attached. All of this is important because if it's not done that way, we might be living in a society of chaos and anarchy. So this punishment helps everyone to be cautious of the fact that if you do anything that is not acceptable, of course, you have yourself to blame and you definitely face the law and be punished for your acts. So we'll now go into the next slide that tells us about the purpose of criminal law. The purpose of criminal law is to regulate human conduct by punishing those who commit or do certain prohibited acts, which the law enjoins them to do. Thus, its main objective is punishment of a convicted offender. Of course, as we go on, we'll find out that this purpose or the aims are numerous. For instance, is to deter when crimes are being committed. For instance, when somebody steals or other, and you have to jail that person or commit that person to terms of years or to some fines, the main essence is to deter others in the society from stealing or for committing further crimes. Again, the purpose also could be retribution. One has committed a crime, and for that, he has to pay for it in order to assuage the feelings of the society. So these are some of the aims of that. The aim also could be to reform the person. It could be also to educate society, because when people or members of the society are aware of crimes and what it entails and the punishments that are that are being prescribed for them, there's that awareness, and this makes everybody knowledgeable and also to know their limits, to know where to should stop in order not to create chaos and anarchy in the society. Again, the main essence of the whole thing, unlike civil law, where it is mainly compensation, in criminal law, the main objective is punishment of a convicted offender. This will take us to the next slide, where we shall look at some of the objectives of criminal law. Yes, like we said from the last slide, we shall look at the objectives of criminal law. What are those objectives that the criminal law starts to, what are the objectives, what are the aims? Every legislative enactment in the country has a particular objective which it intends to serve. The main objective of criminal law are as stated below. One is the need to preserve the moral fabrics of the society. It is in this context that we have offenses like indecent assault, rape, and other forms of offenses that come under this. Of course, we know that moral fabric of the society must at all times be protected. If not, we'll see a lot of evil going on in the society. There's also the need to protect human dignity and human harm. Offenses like this include criminal defamation of character. It also includes assault. Now, if this is not done, if one will feel debased and all that, and of course, that will not be good for the society. There's also the need to protect valuable property of individuals. And offenses under this will include arson, stealing, armed robbery, receiving under false pretenses. Again, the aim is also to protect valuable property of individual. This will ensure that wherever you are, you can sleep with your eyes closed without fearing or believing that people are after you or after your property. So offenses or whatever punishment is being prescribed deters others from engaging in this form of offenses. There's also the need to preserve the state from disintegration, and this we see offenses like sedition, official corruption, contempt of court, treason, and so many others. It is very, very important that the state is protected. If this is not done, it will not augur well for the state, and this offense serves those purposes of protecting the state from further disintegration. We shall go into the next slide to look briefly at the history and other things under criminal law.